Ati former kwa Badela Update TV na message and how about channel is a hit and subscribe so me dropping the latest news content about Jibre. Na once one saka be no be etie na ye bora and seminoma etie for and sema ebo popano. Pressure on Godfred Odame to resign. Yes, NDC lawyers need James Godfred Odame and resigning. Ni nyina so mo James after Supreme Court ruling no Godfred Odame and some okeke kan Supreme Court watch say NDC lawyers no represent Abamba no. They are being disrespectful to the Supreme Court judge. Judges no. Ni nyina say oman febu man NDC for so retaliate Godfred Odame chese won so ania mo a wo ye ya efa japa ehun nsem yi no ohun nsem kran ebon mu a asese by this time ya prosecute you na so nsem binti ene say hine ba ne de ne papa ete akonyamo na mepese yeburum niti omon nsem no bia efa Godfred Odame ho ye ba.
You see, I've always had a problem with Godfred Odame. And I say that not because of anything. Even if I'm not a member of the bar, I expect that, for example, if I were to go to the hospital, you should conduct yourself as a medical doctor in a very professional manner. You should uphold the ethics of your profession. If I were to come and talk to a journalist like you, I expect you to hold the ethics of your profession. This is a gentleman who has, in any way, created an image of the Attorney General's office that seems to be very terrible. And I'll tell you, there's somebody who, in any jurisdiction, he should have resigned by virtue of what he did with the Ãttḥcks trial. In any jurisdiction, he should have resigned. He has no moral right to even sit down and talk about anything. For such a person to go to the Supreme Court and be talking about the fact that either the Speaker or his representatives or legal representatives were disrespectful to the court, he should be the last person to be making those comments. And just as Martin Pegu said, you did not even know exactly what the circumstances were. Besides that, usually the right to defend yourself or the right to defend your actions before any law court, it's a right that you can decide to excuse yourself of it. And so it does not necessarily suggest, if I decide, and that's why the courts will normally, you go, they serve you if you refuse to appear. They rule, because it means that you have exercised the right not to defend yourself. And so the court goes ahead to it. That does not in itself mean that that's disrespect. But every time he wants to play to the gallery, and these are some of the things he does, and it appears to be going on. And if you look at him, from every bit of his actions, you see crime all over the place in the way he behaves. Crime all over the place. And I tell you, look,
what's the crime in this case?
Listen to me. Of course, the fact that what he did with the Ãttḥcks case is clear. Case for trial. It's a clear case for just prosecuting him. But you see, we're in a system where these things happen. But I'll tell you, and I'm assuring you on this, that you will see the other side of Odame post January 7th.
The other side?
Yes, the side that people do not know.
Which is?
Look, that's what I'm saying. I said the side that people do not know. That's what I'm just telling you. So don't be in a hurry to get it now. But I'm saying the other side that people do not know about Godfred Odame. You will see it post January 7th. But just to indicate that he wants to always take advantage of some of these things and then deal with them. But now to the issues. Look, I was excited when I do not know the reasons why Mr. Speaker did not go, because the issue has to do with Mr. Speaker, Parliament, and that. And I cannot pretend to know the reasons why his representatives did not go. But I was excited when he didn't go.
Why?
Look, I'm telling you, why do I go to a place where I know that I'm not going to have fair trial?
Why do you say that?
I'll tell you. And I am happy that today we are discussing this. I know by now, because it's a huge media house, you have come across the issue of the Mo Ibrahim.
Why?
His concerns. You see, much earlier, after the court proceeding, Mr. Godfred Odame introduced something into the conversation that Tadio Sorry, who had been retained by the Speaker as his lawyer and his law firm, did not have the necessary approval from the PPA, and for that matter, lacked the standing to represent the Speaker, and even proceeded that by reason of the constitutional provisions, Article 88, he, Odame, the Attorney General, should be the one representing the Speaker. These 2 points were made by him. What he didn't also tell us is that, you see, the Supreme Court has already, in the case of Janet Amegashe versus the Attorney General, raised the same constitutional point and said, look, yes, it's true, the Attorney General has some powers under Article 88 to represent the government. However, imagine the Attorney General being the one representing the judiciary. It has the potential of undermining and compromising the independence of the judiciary. And so the Supreme Court, speaking through His Lordship Justice Databa, provided a guideline, a roadmap of what to do in those circumstances. And Godfred Odame is aware. But you see, consistent with his practice is always to play to the gallery, either to incite the court against a fellow lawyer, which he has done consistently. In fact, I have been at the receiving end of that conduct. I recall vividly in 2016, myself and my senior Judge Lowe had represented the Muntie 3, but we represented 2, Akroma and Alista. We were doing our private matter. We went to court one day. I was representing Alhaji Grusa and he represented Vincent Odoche before the late Justice Yeboah. Immediately we announced ourselves as lawyers. He started, oh my Lord, do you know that Eduji was the lawyer for the Muntie 3? Effectively to incite the courts against me. And thankfully the judge saw the diabolics and quickly remarked that, oh, even whilst he was in private practice, because of his inclination to human rights issues, he had to even represent somebody who was accused of murder when nobody was willing to represent. So he sees nothing wrong with it. And so that is the character and make. And so I wasn't surprised yesterday when once again he decided to make fetish out of the absence of Mr. Sorry in court. In any case, what the rules of the court requires is that the party is duly notified of judicial proceedings. The person can elect not to come. And so, for Mr. Dami to infer disrespect from that conduct, again tells you his conduct, which is obviously unbecoming, in trying to, as the leader of the bar, in trying to incite the court, the judiciary, against other lawyers. And I think that 4 years into the office, he should have grown into the office. Look, I mean, this is an office that the likes of Geoffrey Bing, Swansea, in fact, his own boss, Nana Dodankwe Kufado, Papa Uso and Akroma, Ayuko Otu and Co., Marietta and Co., once occupied. And they brought so much honor and dignity to that office. I mean, for the record, this is the only Attorney General who, in living memory, has been caught on tape directly manipulating judicial processes. In any serious country, he should not be holding himself as the Attorney General of the Republic. In fact, the last bar conference in Kumasi, the bar council was divided because there were people in the bar council who said, look, this young man should not be permitted to come and address the bar.
Really?
Yes. In fact, the people who defended him were Samuel Kujetu and Co. They were spirited that he should apologize to the bar. If not, he will not be permitted to address the bar in Kumasi.
Really?
Yes. Yes. Because I spoke to members of the Bar Council, the Bar Council was divided because of the misconduct coming from him. And he has this, I don't know, this is a man who was coaching Jakba. And he has the effrontery. And I've always said, persons whose palm kernels have been cracked for them by benevolent spirits must learn humility and not be parading around like peacocks. What is that? Randy, that said, you see, if you look at the Mo Ibrahim reports, first of all, like you rightly indicated, you are a beneficiary of the Mo Ibrahim platform.
Okay, so the Supreme Court has ruled. There's a 5-2 in favor of Afenyo. I'm told that Justices Stanko and Lovelace dissented.
It's close.
Yes.
Okay.
I love to read dissent.
Yes.
And because you raised the issue of dissent, Randy, I just want to read a very classic dissenting view by Justice Lord Ãttलाग्ks in the famous case of Liversidge versus Addison. And this is what Justice or Lord Ãttलाग्ks had to say.
It's an interesting case. Read it.
It's a very interesting. It's a groundbreaking. You know.
He was a laborer.
And that is what he said.
Yeah.
I view with apprehension the attitude of judges who, on a mere question of construction, when faced with claims involving the liberty of the subject, show themselves more executive-minded than the executive. They show themselves more executive-minded than even the executive. You see, Randy, we are building a constitutional democracy. A democracy that we are hopeful and confident will live.
So interestingly, the panel had the original 5.
So the original 5,
the 5
I think all went to, on the injunction.
Sat on the injunction. Yeah. And then the other 2.
They stay.
They stay. So the other 2, the 2 were Justices Stanko and
so they dissented.
Lovelace. Yeah. So the 2 were added were those who dissented. The 5 who ruled in favor of the stay, all ruled for Afenyo.
But let's not read things to it. I mean, we are just reading too much.
Oh, right.
It's quite
I have just made an announcement.
I know, but let me say, okay, I want to stop us from reading. But
no, the 5 that were, I don't want to say unanimous 5.
Okay.
The 5 that were unanimous in their decision on the stay. Yes, I mean were unanimous. They were unanimous on their view on this. Yes. The 2 that were added
but as you know,
dissented.
Interim judgments are easier to obtain than substantive ones.
Okay.
You just have to show where the balance of convenience lies, isn't it? That's the test.
Randy, I think now that there is a judgment, we can fairly critique it.
Okay.
So I'll proceed.
But again, you trust in the reasoning.
No. Hold on.
You are going to speculate.
Hold on.
Okay.
You see,
it lasted like half a minute.
Oh, okay.
No, they're just reading the verdict.
Yeah.
Once they decide, then
I think usually such ones they'll go to conference and have conference.
Yes.
So usually you won't even get a judgment now immediately. It may take maybe a week or a few days to get it. But you see, I was on the Mo Ibrahim conversation when you introduced the breaking news. You see, when I first saw the Mo Ibrahim report on Ghana, first of all, it's a very credible platform, devoid of the MPP NDC conversation. So when I saw it, I was apprehensive. Because for a long time, if you monitor the Afrobarometer report on the workings of the courts, the reasoning and what Ghanaians have generally said about the court had always provided a cause for concern. For me, the height of it was when the National Security Minister, the Honorable Kandapar, a person who had had considerable working experience with Ghanaian institutions, had cause to tell the court or the judges in their face that when a particular consistent outcome is churned by the court, it has the potential of undermining one critical thing that is required in a democracy, public confidence. In fact, Randy, the only way you and I will have a dispute and would approach the court is that we believe at the end of the day we will abide by the outcome. But the very moment our confidence in the system of adjudication is compromised or undermined in any way, the next will be that we'll be resorting to self-help. And that self-help mechanism is a recipe for chaos. When I saw this Mo Ibrahim report, in fact, I even said, there should be an emergency Judicial Council meeting, at least to consider this urgent matter. Because you see, it goes to the very core of justice delivery. When an international organization, and remember, business people, when they want to invest in Ghana, what they do is to look out for such polls, to look out for such views from credible institutions. Now, if you're a business person and you are coming into the country, and you read from Mo Ibrahim or his report that the impartiality of the judicial system had moved from a record high by not a 1 percentage point, not 10 percentage point, not 20 percentage point, but 30 percentage point from 2017 to date, that should be worrying for everybody. In fact, if you practice from our court, if you're a judge and you are not worried by the Mo Ibrahim Index, its report on Ghana, then there is a problem. For us as lawyers, because we represent foreign clients, when they come, they'll ask you, do this due diligence for me, do A, B, C, D. If they are coming with a perception that our court is less, when it comes to partiality, it goes to the very core. And it even undermines inflow of investment. Because for a foreign investor, there's always a potential that you may have an issue.
In fact, even some of the recent cases at international arbitration,
yes,
that have traveled through our courts, even fortifies this position. The rulings of our courts on some of these cases that eventually ended up at arbitration, and the results from arbitration even fortifies and reinforces this point that you are making.
Randy, so like I'm making the point to you, if you have an investor and he wants to come and invest in this country, and he has any occasion to examine this report, question that we need to be asking is, how confident will that investor have in approaching any of our courts? That, for me, should be a great concern for all practitioners. It has nothing to do with MPP, NDC. My learned friend tried introducing that, it is because the NDC appears to talk down on the court system, and that is what has influenced the Mo Ibrahim Index. With the greatest respect, I mean, these international organizations appreciate the internal political dynamics. And so they appreciate what is called a bias in coming out with these indexes. If the conversation is only about NDC, they may think that, this is politics. But they have been speaking to investors. And those investors, what is the level of confidence that they have in how we adjudicate matters, especially matters involving the government? Randy, I'll give you a classic example. If you recall, there's this company called Imperial Heritage.
Yes.
Imperial Heritage, a business people, they have obtained a judgment from a court. Now listen, this is a judgment that was obtained when evidence was taken. Evidence was taken. And the judge, after everything, evaluated the evidence and on merit ruled against the Republic. If the Republic has any misgiving, you appeal it. In a very extraordinary and novel manner, the Attorney General filed an application to set aside the judgment. One, that the filing fee or whatever that was paid did not commensurate with the claims, and some other issues. And the judge agreed. And on the basis of an application, set aside the judgment that he did upon review of the evidence. I mean, when you do things like this, you will get an outcome. But you will be sending a different message across. Randy, so I am worried. Look, when H.E. John Dramani Mahama presented the election petition in 2020 to the court, one, when the defense was filed, the MPP, their first ground was that the petition should be dismissed because it discloses no cause of action. That was refused. So already the court acknowledged that the writ disclosed a cause of action. So you cannot sit here and say John Mahama presented something to court that was, if not, don't put, when your people ask that the matter be dismissed because it did not disclose a cause of action, the court would have dismissed it. The mere fact that the court agreed and adjudicated evidence was taken is that the court found that there was the basis for coming to court. I have always maintained that we lost a glorious opportunity in refusing or disallowing the Electoral Commission chairperson to testify. Election adjudication is not a mere contractual rate that you come to court with. It is at the core of mandates. It's at the core of people's ability to determine through the ballot board who leads them. But we treated it as the usual contract, and A, B, C, D, and Madame will not, and this is, and it ended it. People are watching. And always remember that the people who are watching are equally sane and intelligent and are picking this. You see, where the impression is being created that anything that makes Akufo-Addo comfortable, the court will either delay it. That thing is fueling a very dangerous perception out there. That Akufo-Addo must be made to feel comfortable, pampered. It's a perception that is dangerous. And you see, Randy, why do I make this point? Immediately, MPs passed the LGBTQ law, the bill. The Constitution provides the mechanism if the president strongly feels that there are constitutional issues, the mode that he must go. That was ignored. And we saw the cease and desist letter from Mr. Bedietu. If you recall, the president started raising issues about the bill when he met the diplomat at the time when there was no injunction application from Richard Delasky. How did the president know that Richard Delasky was going to go to court the next day? Because at the time when Mr. Akufo-Addo was speaking to the diplomats, there was no injunction application. How did he know? Was he the one who sponsored Richard Delasky to go to court?
Richard is not an MPP, by the way. I know him very well. He's a good friend. And I did my post call with him.
Okay.
In fact, he opposes MPP quite a lot.
Okay.
So I know Richard for sure.
I didn't say he's an MPP.
No,
I said
I'm
sponsor.
say that he's not.
No, sponsorship is different.
Well, I agree.
That's why I choose my word carefully.
Yes.
I am saying that when Mr. Akufo-Addo met the diplomats, was there any injunction when he was talking to the diplomats?
I don't know the.
How did you know that the next day Richard the last guy was going to court for an injunction? Was he briefed by someone? So you see, you people should not have the inclination that the people you are in the arena with, excuse my language, adapt. We see what is going on, and we appreciate what is going on.
They are not like me.
But you see, Randy, my friend, and again, look, Dom Levo. At the time the court eventually determined the matter, it had become Pyrrhic victory for Dom Levo. When citizens of the Republic, at the end of this kind of justice, it fueled the Mo Ibrahim report. Okay. Because you see, look at the speed, the alacrity with which this Afenyo market matter had been determined. The same speed relative to Dom Levo. Look at when the president came out with the Imposition of Restriction Act, one of the EIs, and my own professor of international law, Professor Tia, went to the court to challenge the constitutionality of those EIs, among other things.
Ate for you to say some of the update TV no.